Most people think participation in court means attendance. It simply does not. If you were in the room, if you answered questions, if you appeared on the video link hearing, then legally the system assumes you participated in your hearing. But trauma does not work like that. And coercive control does not end when the relationship ends, it mutates. Welcome to Masterclass 2, Unmasking Justice. I'm your host, Samantha. In today's episode, we are examining what I call the illusion of participation, the dangerous legal fiction that says physically present equals meaningful participation and engagement through your proceedings in family courts, because many survivors are technically present while neurologically incapable of functioning. Their body is in the courtroom, but their nervous system is in survival mode. And the system rarely understands the difference. So, let's explore this, the participation trap. One of the greatest procedural failures in modern family court proceedings is the assumption that visibility equals capacity. The court sees attendance, documents, answers, compliance, and concludes participation occurred. But trauma specialists understands something very different. A traumatized nervous system can enter into freeze, fawn, shutdown, distortion, hyper-vigilance, while the person still appears outwardly functional. This means a survivor may forget critical evidence, struggle to process questions, agree to things under pressure, because cognitively they are overwhelmed, so they lose the sequence and the memory cannot recall. They struggle to speak coherently, appear emotionally flat, or become highly distressed during a hearing while still technically participating. And this is where the system becomes dangerously simplistic, because the legal threshold for participation is often procedural, not psychological. So the question becomes, were they there? Instead of, were they actually able to engage safely, fairly, effectively? That distinction changes everything. Article 6 and effective participation. Under Human Rights Act, the right to be heard, every individual has the right to a fair hearing, but fairness is not simply physical access to a courtroom. Fairness requires meaningful understanding, procedural equality, effective participation, and the ability to present your case properly. The principle becomes critical in domestic abuse proceedings. because coercive control directly affects cognition, confidence, memory, concentration, decision-making, emotional regulation, and communication. Yet survivors are often assessed through behavioral expectation designed for non-traumatized people. If they cry, they appear unstable. If they remain calm, they appear unaffected. If they forget, they appear unreliable. If they become overwhelmed, they appear difficult. That the trauma itself becomes misinterpreted as a credibility failure or a credibility issue. And this is where participation becomes collapsing inside the court. Not because the survivor lacks truth, but because the courtroom environment itself produces the conditions of coercive control. Why special measures often fail? The system often believes special measures solve the problem. The screen, video links, separate entrances, remote attendance, and while these safeguards may matter, but they do not automatically create safe environments, because coercive control is psychological. A survivor does not stop experiencing fear simply because there is a screen in the room. The body still recognizes the voice, the posture, the procedural intimidation, the legal aggression, the presence of power imbalance, inequality of arms, and many survivors enter hearings already physically exhausted after months or years of litigation, repeated statements, disclosures, battles, procedural uncertainty, financial stress, and ongoing contact with the perpetrator. So what appears to the court as non-engagement may actually be neurological overload. And this is why practice direction 3AA matters so deeply in family court, because the court has an ongoing duty to consider vulnerability and participation impairment, not once, but for every hearing, which means safeguarding is a continuous issue that has to be recognized, but often safeguarding becomes a tick box exercise instead of a living procedural responsibility. The culture of efficiency versus justice. There is another uncomfortable issue we need to discuss: the issue of modern court systems under enormous pressure. Heavy caseloads, time pressures, administrative backlogs, resources, limitation of resources, and within that environment, efficiency can begin to overtake effectiveness. Hearings become focused on moving quickly, managing lists, reducing delays, procedural completion, rather than ensuring meaningful participation. But speed is not justice. A traumatized survivor cannot always process information instantly, especially under pressure, under cross-examination, under procedural confrontation, under legal complexity or intimidation dynamics. Yet the culture of the court often rewards speed, confidence, fluency, procedural stamina instead of the facts in issue and the actual participation. So participation advantages the party least affected by trauma. This creates what I call procedural inequality hidden behind neutrality. The court appears neutral, unbiased, but the impact is not neutral because coercive control creates unequal participation capacity long before the hearing even begins. Litigation exhaustion. One of the most least understood forms of abuse is litigation exhaustion, litigation abuse, the slow wearing down of a person through endless hearings, repeated applications, prolonged ambushes, financial pressures, uncertainty, delayed resolutions, and emotional attrition. Over time, participation deteriorates, not because the survivor lacks truth, but because the nervous system cannot remain in a prolonged survival mode indefinitely. And this is where many survivors begin to blame themselves. I should have spoken better. I should have remembered more clearly. I should have stayed calm. They blame themselves. But trauma, physiology is not weakness. It is adaptation. So the real question is, why are courts still expecting traumatized people to perform like untraumatized participants within the family court system? This is a reform conversation. We must begin having these serious conversation. It's an uncomfortable topic, but it's a meaningful engagement. It needs to be addressed. Not the same as physical presence. Until the court system understands the distinction, many survivors will continue being seen without even being truly heard. Trauma-informed justice is not about lowering the standards. It is about recognizing the reality, because participation rights mean very little if the environment itself destroys the person's autonomy, capacity to participate. It is not simply a safeguarding issue. It is an access to justice issue. And Article 6, a human right issue, and ultimately a structural justice issue. To every survivor listening right now, if you ever struggle to speak, if you freeze, if you forgot things, if you felt overwhelmed, or you are still going through it, that does not mean automatically means you have failed. No, it means you are trying to show up for yourself. And sometimes the system failed to create the conditions which were meaningful enough for you to participate. It's not the problem with your ability to show up. It is exactly why these conversations need to be spoken about in order for the courts to understand. This is Unmasking Justice, and this was Masterclass, the illusion of participation versus meaningful engagement. Thank you for listening.